when considering any liability for Tony's injury, we do have to consider whether there was a duty of care on your part to Tony. So we would look at the Workplace Health and Safety Welfare Regulation of 1992. In section 9, subsection 2, it is kind of stated that there is a need for the floors to be kept sufficiently clean in a workplace. Also in Wilson and English 1938, it is established that employers do have kind of liability to have a safe working environment, and also that employers are vicariously liable for the actions of other employees against each other. This is really important because it was actually the stagehand's responsibility to clean the stage after the renovations were completed. Also in section 1 of the Law Reform Civil Liability Act, it does kind of reiterate the same thing, that vicarious liability can be established. One of the elements of vicarious liability is whether or not the employee was an employee or an external contractor. This was established in Ready Mix Concrete and Minister of Pensions. It is kind of thought that the difference between an employee and an external contractor is differentiated between kind of how they're paid. So an employee usually has like a monthly payment. They'll have kind of a monthly kind of payment coming into their bank account, whereas external contractors might have a lump sum, and this might not be necessarily reflected on their national insurance. The second element of vicarious liability is whether the employee's actions were a tort. So in this case, it was actually an omission. They omitted to sweep the stage floor before the work continued to take place. And in the UK, usually omissions are not imposable as a tort. However, if you have a special relationship, then it can be imposed in some cases, and this is under section 9 of the Workplace Health and Safety Regulation 1992. So it might be also established that, you know, there was a tort there because of the damages. And the third element would be whether the tort that was committed, whether it was during the course of employment. And for that, we do have a look at Joel and Morrison and the idea of frolic of one's own. This is really interesting because the notion is established that where an employer has given an employee an instruction and they have chosen not to follow it, that's kind of frolic of one's own. And if it was able to be established that, you know, you'd given the stagehand the instruction to sweep the stage floor and that wasn't done, then that could kind of mitigate some of your liability there. But in terms of whether or not there's a duty of care to Tony, it could be kind of a very strong argument that there was a duty of care in that respect. And then if we have a look at breach of that duty of care, the ordinary standard of care applies. There's no special standard because as a company, you're not professional cleaners. But what we do need to have a look at is whether it was reasonable to have the floor cleaned. And that's established in Wells and Cooper 1958. And it was definitely reasonable to have the floor kind of cleaned. In contrast, in Latimer and AEC, it would have been too great of a cost to have avoided that risk, and that doesn't really apply here because the cost of having the floor swept is not very great at all. So after that, we do have a look at causation, and we're going to have a look at the right eye initially. And factual causation, it doesn't actually apply in situations where there are multiple independent causes. So the two causes here are the rock that actually kind of penetrated Tony's eye and then the eye drops the experimental eye drops that kind of were administered after the fact. And in Wiltshire and Essex, it was established that the balance of probabilities is kind of the standard of causation, and that is 51%. But we don't know the percentage in this scenario. We have no evidence to support the experimental eye drops as to how much of a percentage that they swayed the balance of probabilities. Also in McGee, this kind of establishes material increase of risk, and we do know that there was a material increase of risk caused by the experimental eye drops, but again, probability is required, and that's information that we do not have. And in the case of Fairchild, it is established that where the facts can't fit into the normal factual causation test, the but-for test, reasonably or fairly, they can't be applied, that material increased risk of harm may be used. So this may work in your favour in terms of mitigating some of your liability, having the eye drops used, but to which degree there isn't very much precedent. In terms of the Bolam test, when the defendant has failed to act as a reasonable person would in their situation, this in your case, the reasonable employer would ensure that the safety of their employees is a concern, and having the floor cleaned after an event like renovations would be important. So this might kind of be a strong argument for causation of Tony's injury. If all of these tests are satisfied, then Dr. Riff and BBC may be jointly and solely liable, and this would be good for yourselves, because the liability reduces from 100% to one that can be debated, and we can kind of introduce mitigating kind of circumstances and arguments. If we have a look at the left eye, the condition that was contracted in the left eye was caused actually by it's either caused by a surgery to the eye or by a penetrating injury. In Tony's case, it was the penetrating injury, and Dr. Riff had not actually breached his duty of care because the surgery was completed competently. But the thing we do have to remember is the but-for test, which is established in Barnet and Chelsea in Kensington Hospital, and this is kind of not really in your favour, because if there was no original injury to the right eye, the left eye wouldn't have also suffered the consequences. So it's likely that you'd be liable for something like that. In terms of damages, there isn't any contributory negligence. Tony didn't do anything wrong in this instance, and this is established in Smith and Charles Baker, so you would be likely to pay damages for personal injury for Tony's eye injuries. When looking at Maria, this is also more of a simple case. So in terms of duty of care, this is established in a very new case in Kerry and Vauxhall 2019. And it kind of establishes that all employers post October 1965 are subject to a duty to take responsible care to prevent exposure of dangerous substances to employees and members of their family. This applies directly to Maria because it was her husband that was exposed to the asbestos and wasn't kind of provided the proper care that he needed for a number of years. And as this kind of pertained to 1990, you would have had like ample time to rectify any issues in the building. So there would definitely be liability there for Maria.